In the last 44 plus years, I have filed and pursued claims against Kaiser Permanente at least 100 times, if not more. Pursuing a claim against Kaiser Permanente is different than filing a medical malpractice claim against other entities, for instance, against Sharp or Scripps or something like that, because they have a provision in your contract where the way to pursue your case is through arbitration. Now, what we do then is once you call me about a prospective Kaiser Permanente malpractice claim, I obtain the medical records that you have. I discuss the matter with you. We then do our best, if we have time, to initially hire an expert who will review those records and determine whether or not any person at Kaiser was negligent and whether or not that negligence caused your harm. Once we do that, we then file what's called a 90-day letter of intent to file a claim along with our demand for arbitration. It is important that we do both of those within 1 year of the date of your injury or the date that you knew of your injury. But to be safe, we always file within 1 year of the date of injury. Once we do that, Kaiser will then send us a set of arbitrators that either I agree with, the defense agrees with, or the defense and I independently agree to an arbitrator. After that, we begin discovery or the process, the civil process to investigate the case formally, just as we would do in a lawsuit. Our interrogatories are sent out, which are questions where they have to answer, we have to answer. We ask for documents. We ask for all the medical records. Even though we might have all the medical records, we still ask for all the medical records from Kaiser for two reasons. One, we want to make sure we have all of them. And two, sometimes we don't have all of them. And we want to make sure that what we have is what Kaiser has. Once all that occurs, we then prepare the case for arbitration. Oftentimes we'll take the depositions of the doctors or the nurses who were involved in my client's care. They will take my client's depositions and any other witnesses. Depositions are simply question and answer period where either in person or by video, they ask questions about the incident, what their damages are, how they were harmed, things like that. Once all that is completed, oftentimes we have settlement conferences. Sometimes we go to mediation, and hopefully we can resolve the case. But remember, Kaiser, like other medical providers, they have to consent to settle. In other words, a doctor can say, I didn't do anything wrong, and I'm not going to agree to settle. At that point in time, we go to arbitration. And arbitration is with an independent judge or a retired attorney who will determine whether or not Kaiser was negligent, that is, committed malpractice, and did they cause any damages? If indeed they caused damages, what is the value of those damages? If you have any questions about pursuing Kaiser, please feel free to contact my office at the number below or utilize the intake form on my website. Thank you.